Hello, my name is Laura Miles and I'm a Senior Associate in the Health Litigation team at Hill Dickinson. Today we're going to be talking about informed consent. To begin with, on the slide you'll see an extract from the GMC guidance on decision-making and consent. Consent is a fundamental legal and ethical principle. All patients have the right to be involved in decisions about their treatment and care and to make informed decisions if they can. The exchange of information between medical professionals and patients is essential to good decision-making. Serious harm can result if patients are not listened to or if they are not given the information they need and time and support to understand it, so they can make informed decisions about their care. Now, let's look at the law. Historically, the legal test applied in consent cases was the Bolam test. What would a responsible body of medical practitioners have done? In 2015, the Supreme Court heard the Montgomery case. In this case, there was a failure to inform the pregnant claimant of a risk of shoulder dystocia and consequently the option of a caesarean section. That risk did eventuate and the claimant's son suffered an avoidable injury as a result. The court found that doctors are under a duty to take reasonable care to ensure that the patient is aware of any material risks involved in any treatment and of any reasonable alternative or variant treatments. The test of materiality is whether, in the circumstances of the particular case, a reasonable person in the patient's position would be likely to attach significance to the risk, or the doctor is or should reasonably be aware that the particular patient would be likely to attach significance to it. It also found that the assessment of whether a risk is material cannot be reduced to percentages. The significance of a given risk is likely to reflect a variety of factors besides its magnitude. For example, the nature of the risk, the effect which its occurrence would have on the life of the patient, the importance to the patient of the benefits sought to be achieved by the treatment, the alternatives available, and the risks involved in those alternatives. The assessment is therefore fact-sensitive and sensitive also to the characteristics of the patient. The Supreme Court provided further clarification in 2023 in the case of McCulloch. In this case, the doctor failed to make the patient aware of an alternative treatment because, in the doctor's opinion, the alternative treatment was not appropriate. The court confirmed that the Bolam test remained the correct legal test for the purposes of determining which treatments were reasonable alternatives, i.e. clinically appropriate. Once the Bolam test had been applied to determine the reasonable alternative treatments, the doctor was then under a duty of care to inform the patient of those reasonable alternatives. The court referred to BMA and GMC guidance and found that they provided strong support for the view that the determination of reasonable treatment options is a matter of medical expertise and professional skill and judgment, and that to require a doctor to outline the risks of all possible alternative treatments, even those considered not to be reasonable, is unlikely to be in the patient's best interests and may impair good decision-making. So let's move on to practicalities. Consent should be obtained any time a clinician wishes to initiate any examination, treatment, or intervention. Patients should also be made aware that they are being asked to take part in research, including the purpose of the research, what it involves, any procedures, the probability of random allocation to treatment, the ability to withdraw at any time, any information about confidentiality or the ability of third parties to access records, and what information they can expect to receive about the research findings. When students or observers are present, patients should be told who and why they are there, ideally in advance of the consultation. This includes when teaching practical procedures on anaesthetised patients. In emergencies, it may not be possible to obtain consent, and this is considered to be an exception, along with limited circumstances prescribed by law, such as under the Mental Health Act. Now, who needs to be involved when taking consent? Taking consent can be delegated, but only to colleagues who have the necessary knowledge, skills, and experience. The GMC suggests that when deciding whether it's appropriate to delegate, you should consider the nature of the intervention and the complexity of the information about it, the level of uncertainty surrounding the outcome, whether the patient has already developed a trusting relationship with you or the person you would delegate to, and anything unusual about the patient's condition and any concerns that you anticipate the patient may have. Ultimately, the obligation for ensuring valid consent rests with whoever is carrying out the treatment. We're now going to discuss timing. It's important to remember that consent is a continuing process. Patients should have sufficient time to reflect on the information given to them. Before commencing treatment, doctors should check that the patient still consents, bearing in mind the length of time since the patient originally agreed, any new information, any significant changes to the patient's condition or circumstances, and where previous discussions have been delegated to a colleague. Patients should be given the opportunity to ask further questions. So what does proper consent look like? Paragraph 10 of the GMC's guidance for doctors on decision-making and consent sets out 5 key pieces of information that patients will usually want or need to make a decision. 1. Diagnosis and prognosis. 2. Uncertainties about the diagnosis or prognosis, including options for further investigation. 3. Options for treating or managing the condition, including the option to take no action. 4. The nature of each option, what would be involved, and the desired outcome. And 5. The potential benefits, risks of harm, uncertainties about, and likelihood of success for each option, including the option to take no action. The GMC's guidance also highlights that information provided should be objective. As mentioned earlier, it's not reasonable to share every possible risk. The conversation should be tailored to each individual patient and their individual circumstances, and any questions should be answered honestly and accurately. We're now going to talk about evidencing consent. In most cases, there is no legal requirement for written consent, with only a very small number of exceptions, such as some forms of fertility treatment and certain requirements of the Mental Health Act. A signed consent form is part of the evidence that the discussion has taken place, but it provides no meaningful information about the quality of the discussion. Details of the discussions that have taken place with a patient and any other relevant people should be recorded in the patient's medical records. This should usually include discussions about the treatment options, including potential harms and benefits of any treatment, any specific concerns the patient had, and any other information that was given to them. The Department of Health Reference Guide to Consent for Examination or Treatment says that written consent merely serves as evidence of the consent. If the elements of volition, appropriate information, and capacity have not been satisfied, a signature on a form will not make the consent valid. Whilst forms aren't mandatory, they are good practice where any significant intervention, such as surgery, is to be undertaken. Consent can also be expressed verbally or non-verbally. An example of non-verbal consent might be where a patient, after receiving appropriate information, holds out an arm for their blood pressure to be taken. However, the person must have understood what examination or treatment is intended and why for such consent to be valid. All the guidance emphasises that the patient's understanding is more important than how consent is recorded. It's important to note that a patient must have capacity in order for consent to be valid. This is assessed in a decision-specific context, and the presumption is that an adult does have capacity unless there are grounds to question it. The patient must be able to understand and retain the information provided to them, weigh up the options, and communicate their decision. Department of Health guidance says that if the person has capacity but is unable to read or write, they may be able to make their mark on the form to indicate consent, and it would be good practice for this to be witnessed by a person other than the clinician seeking consent, and for the fact that the person has chosen to make their mark in this way to be recorded in the case notes. Similarly, if the person has capacity and wishes to give consent but is physically unable to mark the form, this fact should be recorded in the notes. Or the person can direct someone to sign the form on their behalf, but there is no legal requirement for them to do so. If consent has been given validly, the lack of a completed form is no bar to treatment, but a form can be important evidence of consent. We're now going to move on to talk about some specific case examples related to informed consent. In HQA, the claimant was a 25-year-old woman undergoing open heart surgery. During the surgery, a recognised risk materialised, leading to a catastrophic brain injury. There was an additional step that the surgeon could have taken to mitigate the risk of this complication, but the surgeon did not explain that option to the claimant. Rather than a technical detail of the surgery, the court considered this to be a variant of the surgical procedure, noting that it had the capacity to reduce the risk of death and/or permanent brain injury. It was found that had the option been put to the claimant, she would have consented to the surgery on the basis of the variants being performed. There were further issues here in respect of the fact that the main discussion with the operating surgeon only occurred on the day of the surgery, and he then gave conflicting, albeit correct, information about the risks. The court held that the claimant should have been booked in for an outpatient appointment to see the operating surgeon in advance of the day on which the surgery was scheduled. A and East Kent Hospitals is another good example. This was a so-called wrongful birth claim, where the claimant said she should have been advised of the risk of chromosomal abnormality following a diagnosis of fetal growth restriction in pregnancy. The case is useful in the context of what is a material risk. If the risk had been somewhere between 1% or 3%, or anywhere approaching that level, then the judge said he would have concluded that it should have been raised with the claimant. He preferred the evidence that the risk was 1 in 1,000, theoretical, negligible, or background. The court determined that the evidence did not show that there was a material risk to which the claimant should have been alerted. In Spencer and Hillingdon, the claimant alleged a failure to warn him of the risk of DVT or pulmonary embolism and the symptoms of these following hernia surgery. Following discharge, he was diagnosed with bilateral pulmonary emboli. The court found that the hospital had failed to advise the claimant at any time whilst he was in their care of the life-threatening significance of symptoms of the kind he suffered and the consequent need for him to urgently seek medical care if he suffered such symptoms. In his considerations, the judge said, "I asked myself the question, would the ordinary, sensible patient expect to have been given the information contended for? Put another way, I asked myself, would such a patient feel justifiably aggrieved not to have been given on discharge the information contended if appraised of the significance of such information? I consider that, on the evidence before me, the answer to both questions should be in the affirmative. The claim succeeded." Our penultimate case is Teffo and Johnston. The claimant here suffered from constant back and leg pain, for which she was recommended a discectomy. The surgery was unsuccessful and the claimant suffered further nerve damage. She said she was advised that she would recover over time and her pain would resolve, but had she been properly advised that the chances of a full recovery from her back pain in particular were nowhere near as optimistic as portrayed, she would not have consented to the surgery at all. The claimant was told that the surgery had a 90% chance of ridding her of her leg pain, but the back pain was not quite as likely to settle. The risk of nerve injury was quoted at 0.1%. She was not told that the chance of ridding her of her back pain was estimated at around 50%, that there was also a 5% risk of exacerbation of her condition, and that the risk of nerve injury was more like 1%. The court found that the claimant was not properly advised of the risks and that had she been, she would have deferred and sought a second opinion. Our final example is Mills and Oxford University Hospitals. In this instance, the claimant should, amongst other things, have been advised that the endoscopically assisted technique was a novel technique, still in its evolution and not well established, that it would have given more limited access, and it is possible that this could pose a greater risk to structures and vessels that were not within the surgeon's direct line of sight. They should also have been advised that if untoward bleeding were to occur, it would make visualization and controlling the bleeding more difficult and may result in the need to extend the opening. And finally, that the risks and benefits of using the endoscopic technique were unclear. The court found a breach of duty for A, not offering a microscopically assisted resection procedure as an alternative to a minimally invasive endoscopically assisted resection, and B, for not explaining the comparative risks and benefits of these alternative surgical techniques. Had he been properly advised, it was found that he would have opted for the microscopically assisted procedure, which would have been able to control the bleeding that occurred, avoiding the subsequent stroke. We're coming towards the end of the session now, so I will wrap up with some useful guidance to look out for. As you can see from the slide, the Royal College of Surgeons, the BMA, GMC and Department of Health have all provided useful guidance for clinicians on the consenting process, which you can access. In summary, informed consent is about obtaining a real autonomous choice, not simply obtaining a signature or reciting risks. That concludes this session. I hope you found it useful. If there's anything you're unsure of, please feel free to get in touch or visit hilldickinson.com.